One of the last acts of the Alberta PC government prior to the May 2015 election was the passing of Bill 10, an act to amend the Alberta Bill of Rights to protect our children. It had been shelved around Christmas because of the controversy it created over gay-straight alliance clubs. But on March 10th of this year, in a matter of less than 3 hours, it was dusted off, debated, voted on, and passed into law nearly unanimously. Only 2 MLAs opposed the legislation. As of June 1st, it is law for all in Alberta, including independent Christian schools. We hope to explain how this new law isn't really about promoting safe schools or diversity. Rather, it's a revolutionary law which undermines parental authority, which imposes a secular humanist belief on all schools, and it undermines freedom of association, oversteps the authority that God has given to the state, and will do very little to actually combat bullying. The question we then have to answer is what can be done about it now that it is law. My name is André, and I serve as legal counsel for ARPA Canada. I'm joined today by ARPA's Executive Director, Mark Penninga. Mark, if you could boil this all down, what exactly does Bill 10 actually change in Alberta's law?
Well, André, there's so many reasons why this is one of the most troubling laws passed in recent years in Canada. I'm going to focus on just 3 of those reasons. Now first, the law requires that if just one student requests an activity or an organization intended to promote a learning environment that respects diversity and fosters a sense of belonging, the school must permit that activity or organization. That's the most problematic part of Bill 10, and it goes beyond gay-straight alliance clubs, and it includes every activity. It also applies to every school. What that means is that if a student were to request a pink shirt day, for example, the school must comply. If a student in a Christian school were to ask that the school pull down its flag and hoist up a rainbow flag, the school must comply. It's not up to the schools to shape the request or to come up with some other way to meet the student's wishes. Immediate action is required.
So it sounds like private schools can't shape these requests their own way. So, for example, can a Christian school set up a distinctly Christian club to address this particular request from a particular student?
It's a good question, André, and it's something that we hear quite often. As the law is written, every school must immediately support whatever club or activity a student requests as it is requested. They can't change the name or the purpose or the activities. If a student in a Christian school requires a gay-straight alliance, the school must provide a gay-straight alliance. But there's also other problematic aspects to this bill in particular. A second big problem with Bill 10 is that it adds the terms sexual orientation, gender identity, and gender expression to the list of prohibited grounds of discrimination in the Alberta Bill of Rights. Now, André, I know that you've spoken to this issue a number of times, including as this similar bill was before Parliament and in the Ontario Legislature. What's the issue, really, with adding these terms to the Bill of Rights?
Well, Bill 10 is now enshrined in provincial law in Alberta, a principle that biological sex is not fixed, but it's fluid, that there are more than 2 genders, and that what ultimately matters is how one person feels about their own gender, rather than what their actual biological sex markers really are. Now, the Bible has plenty to say about this and about human sexuality. Most basic to our understanding of sex is that God has created 2 and only 2 sexes. Male and female, he created them, Genesis 1:27. Now, all the modern day speculation about numerous sexes, or even a gender continuum with unlimited genders, that's unbiblical. Now, this change in law, it fundamentally twists law and public policy so that they now depend on how a person feels about themselves rather than what they really actually are, or being based on any sort of objective reality. Law changes from something that's based on characteristics that can be objectively measured and evaluated as true and real, and it changes to being based on characteristics that are purely subjective and thus arbitrary. Now, to be clear, gender dysphoria is a real issue, but the medical literature demonstrates conclusively that it is dysphoria and thus should be treated, not embraced. Gender identity and gender fluidity is a political theory, not a medical one, that advances this idea of gender fluidity and advances it at great human cost. Now, for more on this particular issue, I'd urge our viewers to go to arpacanada.ca and search for Bill C-279 to watch a video explaining this particular issue in much more detail. But Mark, there's a third problem with this bill which most Albertans haven't even noticed. Can you speak more to that?
I'd be happy to, Andre. Although the government claimed to be upholding parental authority by requiring parental notification for issues of sexuality and religion, in reality, what the government took with one hand, or what the government gave with one hand, they took back with the other. In reality, they took back far more than they gave. See, this is the third big problem, and that is that the government removed the requirement for parents to be notified if their child is being taught about anything pertaining to sexual orientation. Now, with this change, the Alberta government has decided that education about sexual orientation specifically is not something that parents need to be notified or made aware of. Only specific instruction about sexuality and religion are worthy of special notification to parents. In other words, the Alberta government thought that matters pertaining to homosexuality, transgenderism, just as examples, they can be included in all parts of the curriculum without parents even being aware of that. It's not an issue that parents need to even be informed.
So that's what the Alberta government thinks, and that's what they thought before the election. Now Alberta has a new NDP government which clearly supported Bill 10. And even the leader of the official opposition, Brian Jean of the Wild Rose, claims his party won't legislate on social issues, ironically missing the point. That's exactly what he did when he supported Bill 10. But it's law now. We've got this government. Can anything even be done about Bill 10 now that it is law? I mean, what policy options exist?
Well, we can still meet with the new MLAs. We can explain the problems about Bill 10 and urge them to repeal the law or also to make substantial amendments. Now, we can keep in mind this is something that happens all the time. We'll likely be educating the MLAs, largely because 80 of the 95 are rookies. But amendments and repeals are done frequently. In fact, that's exactly what Bill 10 was, an amendment to the Education Act and Schools Act. So when we sit down with them, we can explain the problem. We can ask them to bring the matter up with their colleagues in the legislature. Andre, can you share some ways in which people can be in touch with their MLAs about this issue?
Sure. This doesn't have to be difficult. Visitors or viewers can go to ARPA Canada's website and use our EasyMail technology to send one of our letters on Bill 10, pre-prepared. In a matter of minutes, you can express your concerns about the legislation. But a phone call is even better. So if you search your MLA's name online, you will find a phone number very quickly. And we recommend that you write out a few points ahead of time and ask to speak with the MLA. But even better than both of these options is to have a meeting with your MLA. Get a few people together, maybe your school principal or a school board member or a friend. Then you email the MLA asking to meet to talk about education policy and Bill 10. If you don't hear back in a couple of days, just do a follow-up call. Now, summer is an ideal time to meet with these MLAs because they're usually in their home ridings. So now's the time to do this.
And Andre, we also want to emphasize with our viewers the importance of sharing with our concerns with the MLAs, even if we think they're going to disagree, even if we've already concluded that, you know what, they're going to support Bill 10 anyways. See, Romans 13 makes it clear God has put these men and women in authority over us. So the first step is to interact with this new government, urging them to uphold freedom of religion, parental authority, freedom of association, a lot of the things we've talked about. Now, given that only 2 MLAs voted against Bill 10, it's unlikely that changes will be made in law. And another option is to initiate a legal challenge against the province of Alberta, making the argument that Bill 10 unjustifiably infringes freedom of religion, freedom of association, perhaps other freedoms. Andre, you're the legal expert. Can you share with us whether legal challenge is even an option, and if so, what would be the cost? What would be the requirements involved?
Well, as our viewers know, ARPA Canada was heavily involved in intervening in the Loyola Supreme Court case over the past few years, and we were encouraged by the decision that came out earlier this year. And we're convinced that this decision from the Supreme Court relates also to Bill 10 in Alberta, and it affirms that the state cannot require an independent Christian school to promote a worldview that contradicts its own religious beliefs. The Loyola decision, I think, provides sufficient grounds to declare that this absolute nature of Bill 10 unjustifiably violates the freedom of religion and conscience of Albertans. Now, a legal action of this nature could take up to 5 years. The reality is that ARPA Canada has a lot of other work to do and is already involved in a number of other court cases. Furthermore, as far as costs go, the court challenge of this nature, it could cost approximately $50,000 at each level of court. There's 3 levels if it went to the Supreme Court. And there's also the risk, if we should lose in the end, that we would have to pay the costs of the other side.
Well, it seems clear then that a bigger question is whether Albertans are motivated to do something about Bill 10 and these broader challenges to our freedoms. This will be a substantial undertaking. And at the same time, if freedom requires eternal vigilance, surely each of us can do our part today. After all, we sure aren't doing this in our own strength. God promises us that as long as we walk with Him, He'll never leave us or forsake us. We're blessed with so much, and we can also be expected to do a lot. Now, we look forward to hearing from Albertans about how your meetings and your phone calls go with your MLAs, and what your thoughts are on pursuing a legal challenge. Send them to us. It's Mark at arpacanada.ca, Andre at arpacanada.ca, or phone us toll free, 1-866-691-2772.
Well, thanks for joining us and taking the time to learn more about why Bill 10 must be challenged. Please share this video with your friends in the broader community. Till next time.